injunction today? Or the bench? Y'all want me to rule on the bench?
Now, beyond that, the notion that the harm that comes to an individual who wants...
Do you want the court submitted on the merits, on the briefs that have already been submitted, or do you...
Fordice specifically noted that at the time the Mississippi Constitution was adopted, abortion was legal until quickening, some 4 to 5 months in pregnancy. So the status quo that we seek and that we ask you to maintain is the status quo that has existed in the state of Mississippi, except for a very small period of time. And that status quo is required to prevent the irreparable harm that would come from the enforcement of an unconstitutional law, the irreparable harm that would befall our client, Jackson Women's Health Organization, which would be required to close its clinic, keep it closed. Because otherwise, its doctors, including one of the plaintiffs, its nurses, its staff, could be subjected to 10 years in prison for just doing their job. Its doctors, its nurses could have their professional licenses taken away.
You don't need our state Supreme Court to tell you that, Your Honor. It's already signaled that in Columbia Mutual Life Insurance itself.
But more importantly, the patients of the clinic, the women of Mississippi who do seek an abortion, who do make the decision that under the law only they can make, not the state, about whether they should carry a pregnancy to term and give birth, they will be forced to do those things against their will, many of them. So that is irreparable harm. And the status quo should be enforced by the court given the binding precedent of pro-choice versus Fordice that protects those rights of the individuals, the women of Mississippi. And so we simply ask that the court enforce that precedent, issue an order to preserve the status quo so that for the moment, while we litigate this case, we remain in the same legal posture that Mississippi has been in, more or less, for nearly all of its existence.
The Supreme Court applies a rule that when one case rests on an earlier case's holding, and the earlier case is overruled. In the past 2 weeks, the state of the law has changed dramatically, and the court needs to decide this motion based on the law as it now stands. You know, if this suit were filed a month ago, if this hearing were 2 weeks ago, things would be very different. The plaintiffs would have a much different claim. But, you know, and that's because 2 weeks ago there was a Roe versus Wade, there was a Planned Parenthood versus Casey, and there was a pro-choice Mississippi versus Fordice. That's no longer true. As a result of the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization, there is no Roe versus Wade, there is no Planned Parenthood versus Casey, and as a result, there is no pro-choice Mississippi versus Fordice. First, Mr. McDuff mentioned, kind of invoked the point of a Bill of Rights is
a legal issue that there would be no witnesses presented. We'll take this under advisement. The court expects to be able to publish a decision